This is TWiT.
A court recently ruled that we needn't give law enforcement the finger. I mean, our finger. Our finger.
Our finger or face.
So
or
Thomas Brewster, who is Forbes' cybersecurity reporter, yesterday ran a story with the headline, "Feds Can't Force You to Unlock Your iPhone with Finger or Face," judge rules. A California judge has ruled that American law enforcement, Thomas wrote cops, can't force people to unlock a mobile phone with their face or finger. The ruling goes further to protect people's private lives from government searches than any before and is being hailed as a potentially landmark decision. Now, of course, we've talked about this at length, whether where, for example, what was the standing law before was you could not be compelled to divulge something you knew, like a password, because that was being called testimonial, but something you were, like your face, your thumbprint, your iris, whatever, was not testimonial. So under that argument, you could be compelled to produce your fingerprint to unlock a device. So this order came, and again, this is the most recent order. It's not that there is no last word until this thing goes to the Supreme Court for final judgment. This order came from the U.S. District Court for the Northern District of California in the denial of a search warrant for an unspecified property in Oakland. The warrant was filed as part of an investigation into a Facebook extortion crime in which a victim was asked to pay up or have an embarrassing video of them publicly released. The police had some suspects in mind and wanted to raid their property. In doing so, the feds also wanted to open up any phone on the premises via facial recognition, a fingerprint, or I don't know of any phone that uses an iris, but that was in there too. While the judge agreed that investigators had shown probable cause to search the property, they did not have the right to open all devices inside by forcing unlocks with biometric features. On the one hand, the magistrate judge, which was Candace Westmore, ruled the request was overbroad as it was neither limited to a particular person nor a particular device. So they were just saying, whatever we find of whoever's it happens to be, we want to be able to, see inside it. But in a more significant part of the ruling, Judge Westmore declared that the government did not have the right, even with a warrant, to force suspects to incriminate themselves by unlocking their devices with biological features. And as we know, previously courts had decided that biometric features, unlike passcodes, were not testimonial. That was because a suspect would have to willingly and verbally give up a passcode, which is not the case with biometrics. A password was therefore deemed testimony, but body parts were not, and so not granted Fifth Amendment protection against self-incrimination. So then this created a paradox. How could a passcode be treated differently from a face or finger when any of the three could be used to unlock a device and expose a user's private life? So where we are now is that Judge Westmore focused there on her ruling. She declared that technology is outpacing the law, writing that fingerprints and face scans were not the same as physical evidence when considered in a context where those body features would be used to unlock a phone. So in other words, specifically saying that for the case of unlocking, these are being held as different. So anyway, as I said, this is a flip from where we've been, but various judges as we have seen in various parts of the country make various decisions based upon their particular reading of the case and specific examples. I think it's going to take the Supreme Court ultimately to make a decision as we move forward about what is and is not usable for unlocking our devices. And who knows the way it'll come down. We're seeing judgments now on both sides.